Your Honor.
Mr. Manning, you ready?
Judge.
Who are you ready on?
This is Mr. Odell or Odell. I'm sorry, Mr. Posey.
I'm sorry, what did you say?
Mr. Posey.
Posey. All right. This is cause number CR 25-53, State of Texas versus Randy Glenn Posey for pretrial. Go ahead, Mr. Manning.
Judge, at this point in time, we received an offer. My client would like to have some time to discuss that offer as well as to go over the discovery. So we asked for some additional time to do so.
All right. I show that we're set for pretrial today, so I'll set up a docket call December 4th.
Yes, Judge. Yeah.
All right. Who's next?
Judge, Mr. Richardson. Sorry, Mr. Paul Richardson.
Paul Rodney Richardson, CR 25-171 for docket call. Go ahead.
Yes, Judge, we're set on CR 25-171. My understanding was that for some reason my client got pulled out Monday for court on Monday.
Over for 6 or something.
Okay. On this case, I want to make sure that this was still filed up here and hadn't been transferred downstairs.
Still on my docket, so I don't have any reason to believe that it was transferred. Is there a chance that Mr. Hartwell, do you have any other prosecutions on Mr. Richardson for any other charges?
Let me double check, Your Honor. I don't think so, but.
And it wasn't for Attorney General or anything like that, correct?
No, my client was very specific that it was for this offense as titled. The reason I was concerned was,
oh, I'm sorry, Mr. Manning, go ahead.
The reason I was concerned was as I am his attorney on all his matters, I wasn't notified of his court appearance nor of a transfer.
And Your Honor, all I see is one other unfiled misdemeanor. The only thing I can think is that since this is a state jail, ordinarily it would have been filed in the county court at law. And it just got indicted in the district court rather than county court at law. That's the only thing I can think for the mix-up.
Yeah, but we're on docket call, so we've been in this court for quite a while now.
And Judge, we're fine with remaining in this court. I just want to make sure that something hadn't happened without my knowledge. As I do represent him on this charge, I want to make sure that I'm at all court proceedings. Judge, our announcement on docket call is that we announced ready. We request to be set on jury selection.
What occurred in court downstairs in the county court of law? What does your client say happened?
They just read the charges out to me. I told them, I already have an attorney. County court said we were supposed to have a case. He said, well, maybe it got filed over here. And it was just kind of like a back and forth. And they said, we're going to reach out to you.
Okay. I don't know if you're able to hear that, but basically he was called out. They read this charge out to him, so that it typically is filed in county court at law. But they went back and forth and finally made the decision they're going to reach out to me. However, I've not received any communication from the county court at law or from the DA's office misdemeanor department.
Okay. Yeah, I'm not sure, Mr. Richardson, what the mix-up is. I understand that usually state jail felonies, in large part, do end up in the county court of law due to the standing order. And it may be that the county court of law saw that you were in custody on a state jail, and they wanted to make sure that you were being brought to court. So, all right. So what we'll do is, what offer was extended to Mr. Richardson that's been rejected?
Judge, I would, my most recent notes say there hasn't been an offer, but my client has maintained his innocence throughout the entirety of the case. We reviewed the discovery, for portions, together, and then I reviewed the remainder of the discovery. And he wishes to go forward based on discovery or lack of discovery for this.
Okay, so it doesn't matter any offer that was made, he rejects it.
That is correct, Judge.
Okay, and he understands that the court may not allow him to be involved in plea negotiations after today if we set him for trial.
Judge, I believe that I have explained that to him. You understand that?
Yeah, but I need to see a discovery though.
Yes.
All right, and did you say, Mr. Manning, that he hasn't seen discovery, or you haven't seen discovery?
We've gone over part of the discovery. The other part of the discovery was listed in the unfiled case, and I didn't have access to that until after I met with him for the first discovery meeting. He and I are going to go over that before we go to trial. But I have reviewed it and have relayed that to him.
So you've reviewed all discovery. He's only reviewed partial discovery.
That is correct, Judge.
All right, court will place Mr. Richardson on the trial docket beginning November 3rd. And I'll notify you if you end up in the top 10.
Thank you, Judge. Hold on, just a second. 8:30, correct? Go sign that. Okay. Bob.
All right, who would you like next?
Judge, next we have Mr. Vincent Odell.
This is cause number CR 25-170, State of Texas versus Vincent Everett Odell for pretrial. Go ahead.
Yes, Judge. I apologize. Give me just one moment. Judge, I have recently received an offer. I believe it was yesterday or the day prior, regarding Mr. Odell's case. We'd like some additional time to consider that in light of the discovery and discuss some potential defenses, for this case.
No contested pretrial motions.
None at this time, Judge. I have not had an opportunity to go over it with my client at this point.
All right, court will set Mr. Odell then for docket call December 4th.
Next, we have Mr. Judson Wilson.
Court calls cause number CR 24-227, State of Texas versus Judson Wayne Wilson. This is also cause number CR 24-228. Go ahead, Mr. Manning.
Judge, I've had an opportunity to go over the indictments in these cases, explain the range of punishment as well as the charges. He understands both the charges and range of punishment, pleads not guilty, and requests his name is spelled correctly, and pleads not guilty, requests to be set on the pretrial docket.
All right, the court finds that the defendant has waived the formal requirements of arraignment. The court does enter his plea of not guilty into the record in each cause and sets the matters for pretrial on December 4th at 1:30. Should the defendant make bail, then the hearing will be at 9 a.m.
Yes, Judge. Judge, next ready on Miss Dorothy Harvey.
Harvey. This is cause number CR 25-132, State of Texas versus Dorothy Louise Harvey for docket call. Go ahead.
Yes, Judge. Mr. Harvey received an offer of 3 TDC, and she has rejected that offer and requests to be set on jury selection docket.
All right, the court finds that the defendant has rejected the state's plea offers. The court will set this matter for jury selection beginning November 3rd. And I'll notify you when she ends up in the top 10.
Thank you, Judge. Judge, we're ready on Mr. Patrick Richardson.
All right, Mr. Patrick Richardson, cause number CR 25-186 set for pretrial. Go ahead.
Judge, we have no contested pretrial at this time. Request to be set on docket call.
All right, court sets Mr. Patrick Lee Richardson for docket call December 4th at 1:30.
As soon as I hear from the DA's, I will let you know.
Who's next?
Judge, next on Miss Wendy Paul, but before we begin the plea, we have a discussion as a part of the plea before we begin the formal plea process.
Okay.
Judge, as Miss Paul and the state have reached an agreement to resolve her motion to adjudicate at 5 years TDCJ. The question is her time credit. Miss Paul was given 89 days jail credit for her time spent here in Van Zandt County. However, Miss Paul received a sentence out of Kaufman County I apologize, give me just 1 second. Apologize, Judge, our internet's running a little bit slow out here.
Okay.
I believe it was in 2022, Judge. And as soon as I have the exact date, I will let the court know. I forwarded that both to the state and to the court coordinator. But she received this judgment in Kaufman County and then began writing Van Zandt County letters, which I would ask the court to take judicial notice of the court's file, where she filed multiple letters, 2 of which were filed in 2023, requesting that a warrant attach while she was in TDC and that she have her probation revoked to resolve her business and take care of her sentence here as well as her sentence in Van Zandt County. The state notes that the attachment for her warrant did not come until she was released from TDC in 2024, which is why she does not have as much credit as she should be entitled to. We believe the time, including the sentence on the judgment, should include approximately 16 months of back time credit that was not agreed to or verified by the state.
I'm sorry, yeah, the internet's kind of cutting in and out. When was the detainer placed on Ms. Paul while she was in TDC custody?
It was not placed until 2024, despite Ms. Paul writing the district clerk's office multiple times, requesting that a warrant attach and letting them know where she was located, how to place a hold on her, and that she would wish to take care of her probation, resolve her probation case, and get off probation.
All right, give me just
And
a
Judge,
moment.
yes,
Go
Judge.
ahead. I was gonna say, give me just a moment. Let me go read these letters that's in the file real
Yes,
quick,
Judge.
just so I can get familiar. Give me just one moment.
Not a problem. So what I have is letter. See on this letter, it was filed July 20th. So see it just July 18th. Wait. See this one was filed October 30th, October 18th. Yeah, right. Yeah. No, doesn't look too letters that we will find in the file. So you have it in someone's office or other lawyer. The file that you do the right thing. So hopefully, I mean, okay. So they can do that. So they Thank you. If you get some, that's not soon. Yeah. He said he's been taking this sneak. I take my phone and got him.
All right, and so Mr. Manning, we're gonna be off the record for a moment just as we kind of work through this.
Exception.
And so it's gonna be hard for me to hear if everyone else is talking in there. Microphone's real sensitive. I can pick up their whole conversation. All right, so I see that Miss Paul, okay, you're talking about in 23, July 20th of 23. I see that she sent a letter to the clerk. Is that the date that you're referring to?
That's correct, Judge.
Indicating that she's in TDC. Okay. KPS was issued in February 22nd of 24. And then I see a motion to withdraw the motion to adjudicate in April of 24, where she did 167 days as a condition of community supervision. Are these
Correct.
the dates that we're talking about?
No, Judge.
So she
So,
wouldn't get, you're saying,
Judge, their custody time that I have is from November 4th, 2019 to February 4th of 2020, which was the original offense. She has 93 days. That was eaten up as the part of the condition of probation when she signed back on. Then in February 16th of 2024, which is the date you're referencing, and April 30th of 2024, that was the additional time that was used as the motion to adjudicate was withdrawn and her time was eaten up. What our argument is that from 2023 in July, when she requested, the hold was not placed on her as it should have been at her request, which left her short of time that was not credited to her incarceration on this case, but just to the Kaufman County case that she was in TDC for.
all right, so give me the beginning date that you're asking for.
We are requesting the judgment that was filed by Kaufman was, I apologize, I just switched out of that. Give me just one moment. It was imposed 12/14 of 2022. Unfortunately, we were unable to locate any of the letters that Ms. Paul sent from Kaufman County or from her initial incarceration at the Woodman unit. We were unable to locate any of those letters. They may have been sent to previous counsel or to the DA's office, but we're unable to verify those. What we are able to verify is that on July 20th, 2023, until February of 2024, she did not have a hold on her from Van Zandt County and should have had. So we would request from July 20th of 2023 until the hold was placed in 2024, we would request those dates as credit.
24.
That's correct, Judge.
Okay, let's go on record then. We're back on record at cause number CR 20-352, State versus Wendy Marie Paul. All right, Mr. Hartwell, what's your position, or Mr. Hernandez, what's your position on the defendant's request for additional jail time credit for the time that she spent in jail on this cause between the dates of July 20th of 2023 till February 22nd, 2024?
Your Honor, the state's not opposed to any back time that Miss Paul is entitled to. I know we've had a situation before where there was a hold that was requested and not placed, and I can't quite remember what the law says about when a hold is requested and not placed, and I know there's a process for that. I don't recall exactly what that process is, but the state is not opposed to any credit time that Miss Paul is entitled to.
So, Mr. Manning, I think the credit time, if any, that she was going to be given in addition would be July 20th of 23 through February 15th of 24, because February 16th through April 29th was done as a condition of community supervision in her motion to withdraw, motion to adjudicate agreement that she reached.
And Judge, my client, I've been able to go over that with her today, and she's in agreement that that is correct.
Okay, then the court will find that there was a lack of due diligence on behalf of the state, placing a hold on Ms. Paul based on her notifying the court. The court will find that she's entitled to additional jail time credit from July 20th of 2023 through February 15th, 2024. So will you need to modify the judgment to reflect that?
No, Judge, the judgment is left blank for you to fill in the jail time credit. And I don't believe that there was any spot on there that on the judgment that had her jail time credit listed out. So I will provide those dates to the court for the court to assess and place in the judgment.
How much, what will be the total jail time credit?
Well, Judge, I would need a second to do the math
Okay.
on the newly pronounced dates, but I believe.
No, that's fine. That's fine. Go ahead and calculate them, and then you and Mr. Hartwell can look at that together. And if you agree, then we can do that.
Yes, Judge.
Thank you, sir.
You're welcome.
Okay, Judge. I calculate, or I have had my phone calculate that the jail time credit from 7/20 of 23 to February 15th of 24 is
Now, I'm sorry,
200.
can you back up? Because I think maybe my internet is unstable because it's cutting out and it's telling me that it's unstable. So I didn't hear what you said.
I apologize. I show through my calculations that July 20th of 23 to February 15th of 24 is a total of 210 days, plus the additional time that she served from August 28th of this year, 2025, until today is an additional 49 days for a total of 259 days credit.
Would it go through today or would it go through yesterday? I can't
I'm sorry,
remember which.
yesterday, Judge. The Miss Abney did calculate it to yesterday. That's correct.
All right, 10, 15. And how many days is that?
259.
So that was 49 days plus the 210,
That's correct, Judge.
200. So that would be, what about, earlier you said something about 89 days in Van Zandt County. What was 89 from?
Judge, she had 93 days on the original charge, 84 days on the first MTA, and those two were eaten up as a part of her plea on April 30th of 24.
Okay. All right, so total 259.
That's correct, Judge.
This is cause number CR 20-352, State versus Wendy Marie Paul. Ms. Paul, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God.
Yes. Yes, sir.
All right, thank you, Lord. Thank you. Just speak up loudly and clearly for me, okay?
Yes,
All
sir.
right, Ms. Paul. Ms. Paul, you were previously before the court on September 16th of 2021. You pled guilty to the offense of possession of a controlled substance, a third-degree felony. On that day, the court approved a plea agreement and assessed your punishment at 10 years confinement in prison. And the court then suspended that sentence and placed you on community supervision for a period of 10 years. It was during that period of community supervision that the state filed a motion to revoke. And in that motion, they alleged 9 allegations of violations. Have you had enough time to review that motion and those allegations with your attorney, Mr. Manning?
Yes, sir.
Do you understand everything that you have read and signed as part of your plea agreement?
Yes, sir.
It's about, or that we discussed before we go further?
I'm sorry, you're cutting out.
Judge, we lost you there.
I said, is there anything else that we need to discuss before you go further with your plea agreement?
I just have one question. If that's okay.
Go ahead.
I'll still get credit, like my time, sir. I'll still get credit for like today until I pull chain, right?
Yes.
Okay. In addition to my other. Okay, I'm good. Sorry.
Okay.
No
Are you
questions.
happy? Are you happy with Mr. Manning and the work that he's done as your attorney?
Absolutely. Yes, sir.
All right, Mr. Manning, do you believe Ms. Paul to be competent to enter into this agreement? And if she is, do you believe that she's doing that intentionally, knowingly, and voluntarily?
Judge, I do believe she's competent and I believe she is entering into this plea intentionally, knowingly, and voluntarily, Judge. Additionally, she was able to assist in the calculation of her jail time credit, which I believe shows her cooperation and ability to participate in the case.
Okay. And does she waive the formal reading of the state's motion?
She does.
And does she intend to be true to all counts?
She does.
All right, and Ms. Paul, before doing that, I see that you have a plea agreement today on the motion to revoke, wherein upon you pleading true to all 9 counts alleged in the motion, the state's recommending to the court that the court adjudicate your guilt. I think your guilt's already been adjudicated, though.
I think so.
Did I not read that in the? You need to get that confirmed because I think in the state's motion it says 10 pro 10. But this says adjudicating guilt. Give me just one moment. Let me look at my.
Judge, I did not see anything that had where her guilt had been adjudicated. However, a motion to adjudicate had been withdrawn back on April 30th of 24.
Yeah, she has already been adjudicated. Let me share the screen here. Sure. All right, so on September 16th of 21, she pled guilty. Punishment was assessed in prison, and that sentence was suspended, and she was placed on community supervision. So we need to get a new judgment altogether, because the judgment that's presented here is a judgment adjudicating guilt. So let us fix that paperwork, Ms. Paul, and then we will bring you back up and go through all of that, okay? Well, I'll tell you what, let's do it this way. It'll be easier. So, Ms. Paul, you were already convicted on September 16th of 2021 pursuant to a plea agreement in which the court approved, and that sentence was suspended and you were placed on community supervision for 10 years. I see that the plea agreement today is upon you pleading true to all counts alleged in the state's motion. The state is recommending that your community supervision be revoked and that you be assessed punishment at 5 years confinement in the Texas Department of Criminal Justice, with you being ordered to pay the balance of your financial obligations. which includes a $2,500 fine, $100 restitution, $290 in court costs, $170 in reimbursement fees. And you would receive towards that 5-year sentence 259 days of jail time credit for time that you have spent in jail on this cause, to which we have discussed today. Is that your understanding of the plea agreement?
Yes, sir.
I'd ask you at this time, Ms. Paul, how do you plead to counts 1 through 9 as contained in the state's motion to revoke? Are those counts true or not true?
True.
And you're telling me that those 9 counts are true because in fact they are true. You're not just telling me that so you could get a plea agreement.
No, they're true.
Okay. All right. Court will accept the defendant's plea of true to all 9 counts as alleged in the state's motion to revoke. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered, Judge.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, based on the defendant's plea of true to each count as alleged, the court finds each count to be true. On the basis of that, the court finds that Wendy Marie Paul has violated the terms and conditions of her community supervision. The court will follow the plea agreement today. The court hereby revokes Ms. Paul's community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations, and awards her 259 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Paul, we're going to have to redo your paperwork. So Mr. Manning's going to come back and he's going to have you re-sign all of that, but we're not going to appear for another hearing because I've already pronounced sentence. We'll just have to enter it with that judgment once it's corrected. Do you understand that?
Yes, sir.
Okay, very well. I'm going to have you step over. You'll see Sergeant Martinez. He's going to go ahead and take your fingerprint and then we'll get the paperwork corrected.
Okay, thank you, sir.
You're welcome. All right, Mr. Manning, who's next?
Judge, next we have Mr. Hagel.
This is cause number CR 24-232, State of Texas versus Michael Tanner Hagel. Motion to revoke. Go ahead.
Judge, we need to be set on the contested docket.
All right, court sets Mr. Hagel for court's contested docket. Can you be ready in 2 weeks on the next one on October 30th?
Judge, give me just 1 second, please. That'll be a little bit tight. I do have a trial set in Kaufman next week. So that may be pushing it to prepare for that, as well as my preparations for trial the next week in your court.
All right, court will set Mr. Hagel then for contested hearing on December 16th at 1:30. Who's next?
Judge, ready on Mr. Templeton?
Clause number CR 25-115 and 116, State versus Stephen Marcus Templeton for docket call.
Judge, we reached an agreement and you should have the paperwork in your queue.
All right, stand by. All right, Mr. Templeton, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. Good learning. Your name is Stephen Marcus Templeton, is that correct?
Yes, sir.
Mr. Templeton, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
I am.
Do you understand everything that you've read and signed?
Yes, sir.
Do you have any questions about any of the plea paperwork that you've read over and signed today?
No, sir.
Mr. Manning, do you believe Mr. Templeton to be competent to enter into a plea agreement, and that if so, he's entering into this intentionally, knowingly, and voluntarily after having been informed of his legal rights?
I do, Judge.
All right, Mr. Templeton, I see that you are charged in CR 25-115 with the felony offense, second degree felony offense of manufacture or delivery of a controlled substance in penalty group 3 or 4 between 28 grams but less than 200 grams. A second degree felony does carry a range of punishment of not less than 2 years in prison and not more than 20 years in prison, and a possible fine not to exceed $10,000. As part of your plea agreement, the recommendation is upon you pleading guilty, the state's recommending to the court that the court assess punishment at 6 years confinement in prison, along with a $2,000 fine, restitution of $180, court cost of $290, reimbursement fees of $85, and in addition, the state is agreeing to abandon the enhancement paragraph in the indictment, and they're also agreeing to dismiss CR 25-116, which is an evading arrest or detention with a vehicle. Mr. Templeton, is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
Mr. Manning, how much credit time would Mr. Templeton receive towards that sentence?
237 days credit.
237?
That's correct, Judge.
All right, and you agree to that as well, Mr. Templeton?
Yes, sir.
All right, Mr. Templeton, how do you plead to that offense?
Guilty?
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to that offense?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered, Judge.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement today. The court convicts Stephen Marcus Templeton of manufacture or delivery of a controlled substance in penalty group 3 or 4 in an amount greater than 28 grams but less than 200 grams, a second degree felony. The court assesses punishment at 6 years confinement in prison. The court orders Mr. Templeton to pay a $2,000 fine, $180 in restitution, $290 in court costs, and $85 in reimbursement fees. Court finds that the state has abandoned the enhancement paragraph in the indictment, and the court dismisses under section 1245, cause number CR 25-116, evading arrest or detention of the vehicle. The court awards Mr. Templeton 237 days credit towards the sentence for the time he has spent in jail on this cause. Mr. Templeton, when you're released from prison, if you've not paid off your financial obligations, fine, court cost fees, then I'm ordering you to report to the district clerk's office here in the courthouse so you can make arrangements to pay those things off. Failure to comply with the court order could result in you being rearrested. Do you understand?
Yes, sir.
All right. Mr. Templeton, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Good luck to you, sir.
Thank you.
You're welcome. All right, Mr. Manning, who's next?
This is Miss Nix, Caitlin Nix.
Ms. Nix, a plea today?
That's correct, Judge.
Just 1 second.
Oh, yeah.
All right, Ms. Nix, if you will, please raise your hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you. You can lower your hand. All right, your name is Caitlin Shira Nix. Is that correct?
Yes, sir.
And Ms. Nix, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
All right, Mr. Manning, do you believe Ms. Nix to be competent, and if so, that she is entering into this agreement intentionally, knowingly, and voluntarily after being informed of her legal rights?
I do.
All right, Ms. Nix, I see that you are charged in cause number CR 25-127 with the first degree felony offense of manufacture or delivery of a controlled substance in felony group 1 between 4 grams and 200 grams. However, I see that today there is a plea agreement in which the state is making a deal with you to reduce the charge to a second degree felony offense, which has a lower or lesser punishment range of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. And I see that that agreement is upon you pleading guilty, the state is recommending that you be convicted of that lesser offense and that your punishment be assessed at 12 years confinement in prison, along with restitution of $180, no fine, a court cost of $290, and reimbursement fees of $70. Mr. Manning, how much credit time would Ms. Nix receive towards her sentence?
We received the calculations and agree that 142 days credit time is the appropriate back time.
All right, and so you would receive 142 days credit towards your sentence, Ms. Nix. Ms. Nix, is that your understanding of the plea agreement?
Yes, sir.
All right, I also see that while it's not written out in the plea agreement, I do see that some other dispositions of other cases have been provided by the DA's office. It appears that the DA's office is rejecting for prosecution a possession of controlled substance, penalty group 3, less than 28 grams from February 25th of 25, and also a possession of controlled substance, penalty group 1, less than 1 gram from the same date. So the court does see that those are being rejected by the DA's office. So Ms. Nix, at this time, I would ask you, after you understand the plea agreement and the range of punishment, how do you plead to the second degree felony offense of possession of a controlled substance in penalty group 1 or 1B greater than 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection to the evidence as offered, and Judge, as a clarification on those rejections, those cases were rejected, I believe, in June of this year prior to this plea.
Very well. All right, Mr. Hartwell, anything further from the state?
Nothing further, Your Honor. Thank you.
All right, of course, going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby convicts the defendant of possession of controlled substance in penalty group 1 or 1B greater than 4 grams or less than 200 grams, assesses her punishment at 6 years confinement in the Texas Department, I'm sorry, 12 years confinement in the Texas Department of Criminal Justice Institutional Division, orders her to pay restitution of $180, court costs of $290, and reimbursement fees of $70, and awards Ms. Nix 142 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Nix, once you're released from prison, if you've not paid off your fines, court costs, fees, those things, you're ordered to report to the courthouse and make payment arrangements. Otherwise, a warrant could be issued for your arrest. Do you understand?
Yes, sir.
All right. Ms. Nix, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Good luck to you.
So that's additional time for all of that today.
Mr. Manning, who's next?
Judge, this is Mr. Baird.
All right, this is cause number CR 25-153, State of Texas versus Walter Lynn Baird, and also CR 25-164 for pretrial. Go ahead, Mr. Manning.
Judge, I received information this afternoon that a bunch of new discovery had been acquired by the DA's office, and I don't believe I have access to that at this point in time. So I request additional pretrial for my client and I to review that information.
State.
Yes, Your Honor, we've received just continuing investigation reports from law enforcement and have uploaded that. Sometimes it can take a couple hours to hit the portal though.
All right, court will reset Mr. Baird for an additional pretrial hearing December 4th in each case. Who's next, Mr. Manning?
And I believe that's all I got.
I think you got Mr. Barentine for arraignment, Joseph Lee Barentine, and DeMarcus Hyder. Those look like they might be new arraignments.
You ready?
Yes, he's ready.
Do you need me to pull up those indictments?
Wait, we don't have the people.
Judge, Miss Abraham is looking through her docket, but she says we don't have those people.
Why are they going? So we need Bear and Tyler. Hyder.
Okay.
Just a moment, Your Honor.
That's fine. Do you want me to go ahead and pull up those indictments while we're waiting?
That'd be great, Judge.
Give me just a second.
I know why that's being No. Yeah, I gotta glare on that. You can see the, Judge, actually, I apologize. This is Mr. Hyder. We have his,
Well, here's Mr. Barrington.
I'll switch them up.
Judge, which would you prefer?
Let's go with Mr. Valentine, because if I close all this out, I'll have to load them.
Yes,
all.
Judge.
Sorry, Mr. Hyder, we'll be with you just a moment.
Okay.
These are indictments. They were filed on September 19th. So you have the aggravated assault of a public servant, which is a first degree. Yeah, a first degree felony, another aggravated assault of a public servant, and then a unlawful possession of a firearm by a felon, which is a third degree felony. You see on the middle one there, they have an enhancement paragraph, which is going to take amendment from 599 to I believe 1599 life. Is your name spelled correctly? Can you see it?
I believe it is on the copies I have.
Judge, Mr. Barentine's name is spelled correctly. He understands the charges against him as well as the range of punishment on each of those. His plea is not guilty and he requests to be set on the pretrial docket. Additionally, Judge, we also request discovery from the DA's office.
All right, court finds that Mr. Valentine has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record on all three causes. Court will set Mr. Valentine for pretrial hearing on December 4th at 1:30. Should he make bond, it'll be at 9:30 or it'll be at 9 a.m.
I apologize, Judge. Give me just one moment. Get back on the pretrial. As soon as I can just get a real number, I guess it'll be okay.
All right, Mr. Hyder, come on up. This is cause number CR 25-205, State of Texas versus DeMarcus Leon Hyder for arraignment. Give me just a second.
How you doing? Can you see me?
It's the.
Can you see that, Mr. Manning?
Yes, Judge. And Judge, we've had an opportunity to review the indictment on this case. Mr. Hyder's name is spelled correctly. He understands the charge against him as well as the range of punishment and pleads not guilty. Request to be set on the pretrial docket as well as to have discovery in his case.
All right, the court finds that Mr. Hyder, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court will set Mr. Hyder for pretrial December 4th at 9 a.m.
So say present this sign. I don't know that. Say you weren't arrested on this charge previously at your bondsman as well as the DA's office. It was a theft, not on this charge.
No, it shouldn't have been no theft. It was the same charge.
Yeah, well, no. Bond shot on. Having numbers like this. So what do you want to find? As soon as I have discovery, we'll come down to smell.
That ain't telling me nothing. That to me.
That's it for that. So no, that will not do that.
So we just actually did something.
Anything further, Mr. Manning?
Judge, I don't have anything further, and I don't believe Ms. Abraham has anything further. I believe that's for the day.
All right, court has concluded its criminal docket for the afternoon. Court is adjourned.
Thank you,
Thank you
Judge.
everyone for their work.
Thank you, Judge.
You're welcome. Thank you, Mr. Will. Mr. Rodriguez.
Thank you, sir, very much.
Okay, y'all still online.